pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
School City Lighting, in partnership with our community, empowers students to pursue high-quality, personalized educational pathways and grow as responsible lifelong learners who respect and value differences. And roll call.
Roll call, TJ Toles. Chris Davenport.
Here.
Patty Herbst. Here. Tom Ehrlich.
Here.
Rena Mendez. Here.
All right, moving on to new business. We're going to have the first reading of the Neola policies. All of these policies were given to the board in advance to review. First one is PO 0166.1, consent agenda revised. Any discussion or comment? Okay. Moving on to PO 01672, executive session revised. Any discussion or comment? We have PO 1216, dress and appearance revised. Discussion or comment? PO 1220, employment of the superintendent revised. Discussion or comment? PO 2131, educational outcomes for students revised. Discussion or comment? PO 2210, curriculum development revised. Discussion or comment? PO 2221, mandatory curriculum revised. Discussion or comment? PO 2340, field and other corporation sponsored trips replacement. Discussion or comment? PO 2370, educational options revised. Discussion or comment? PO 2370.02, flex program revised. Discussion or comment? PO 2411, guidance and counseling revised. Discussion or comment? PO 2421, career and technical education program revised. Discussion or comment? PO 2623, student assessment revised. Discussion or comment? PO 2700, annual performance report rescind. Discussion or comment? PO 3120, employment of professional staff revised. Discussion or comment? PO 3120.02, adjunct teachers revised. Discussion or comment? PO 3120.11, public hearing before commencement of collective bargaining and public meeting before ratification of tentative agreement revised. Discussion or comment? PO 3142, cancellation of a teaching contract revised. Discussion or comment? PO 3216, staff dress and appearance revised. Discussion or comment? PO 4120, employment of support staff revised. Discussion or comment? PO 4213.01, staff student relations, technical correction. Discussion or comment? PO 4216, support staff dress and appearance revised. Discussion or comment? PO 5111, determination of legal settlement and eligibility for enrollment of students without legal settlement in the corporation, proof of Indiana residency revised. Discussion or comment? Yeah, we gotta take a time out right there. That was a mouthful. All right, back at it. PO 5330, use of medication revised. Discussion or comment? PO 5410, promotion, placement, and retention, revised. Discussion or comment? PO 5460, graduation requirements, revised. Discussion or comment? PO 5462, retaking a class, revised. Discussion or comment? PO 5511, dress and appearance, revised. Discussion or comment? PO 5517.01, bullying, revised. Discussion or comment? PO 5540.01, investigations by the Department of Child Services, new policy. Discussion or comment? PO 6116, time and effort reporting, revised. Discussion or comment? PO 6140, depository agreements and digital payment applications, new policy. Discussion or comment? PO 6151, bad checks and uncollectible debts, revised. Discussion or comment? PO 6230, budget hearing, technical correction. Discussion or comment? PO 7300, disposition of real property, revised. Discussion or comment? PO 7310, disposition of surplus property, technical correction. Discussion or comment? PO 7430, safety standards, revised. Discussion or comment? PO 7440.01, electronic monitoring and recording, revised. Discussion or comment? PO 8400, school safety information, technical correction. Discussion or comment? PO 8405, environmental health and safety issues, indoor air quality, animals in the classroom, and idling vehicles on school property, revised. Discussion or comment? PO 8451, parasitic infestation, head lice, revised. Discussion or comment? PO 8500, food service program, revised. Discussion or comment? PO 8510, wellness, revised. Discussion or comment? PO 8540, vending machines, rescind. Discussion or comment? See that one. PO 8640, transportation for field and other corporation-sponsored trips, rescind. Discussion or comment? PO 9150, school visitors, revised. Discussion or comment? And PO 9160, public attendance at school events, revised. Discussion or comment? All right. That concludes our first reading.
And, Mr. Davenport, just so everybody is aware, when you're saying revised, that's to fix an error or omission based on a legal change at the state or federal level, okay, just so as there's viewers watching. And then a technical change is just minor changes that do not alter the policy's original intent. Okay, so when you were saying technical change or revised, that's what that meant there. Okay, and again, the school board was, given these policies well in advance before this first reading.
If you guys, as you go through any of those, if you guys have any questions or anything about it, feel free to shoot me questions.
Yeah, and then there are still a couple.
Yeah, there's
I
a
don't know if
couple
you
here,
wanna-
and I can kind of go through
Yeah.
these. So 5540.02, and we'll make sure that this gets put into your packet too.
Mhm.
You know, my recommendation, so what this has to do with is that when we have governmental agencies that come onto our school property and they want access to our kids for purposes of maybe interviewing them, maybe a place for coming in to do an interview, my recommendation is that they've got some options in here. And my recommendation strongly is that when it's a governmental agency who's stepping into your school just because they're here and it's easy access, that you're kind of in loco parentis and that you notify the parent before you let them come in and interview the kid who's here. Okay, whether it's the police, whether it's whoever it is. So that would be my recommendation. You know, parents tend to get a little bit protective about their kids being pulled in for, you know, that's not what they expect to happen when they send them to school. So that's the option there. And then the other option in this is that unless it's an emergency, there is a little bit of concern out here broadly. Let me kind of explain this to you and I'll tell you my recommendation and you guys can tell me if that's what you want to do. The policies with regard to governmental agencies coming onto school property and having access to your kids and interviewing your kids is getting newer attention now because of worries about, you know, immigration and ICE coming in, okay? And what we have tried to keep the superintendents informed about, and I know Dave's aware of this too with some of the updates we've given, but what we've explained to school districts is that when you get a judicial warrant from a ICE administrative agency, doesn't really have the effect of a court order or something like that. So we don't tend to honor those. Now, if it's a judicial order that comes from a court or something like that, then we're going to honor that, because when you look at the wording of FERPA talks about being a judicial order, okay? So there's a little bit out here, you know, in terms of, you know, our take on it is that you have to have that judicial warrant. And so my recommendation on here is that unless there's an emergency that's going on, if a governmental agency, doesn't matter what governmental agency it is, if they have a judicial warrant, then we will honor that warrant and we will follow that according to our visitors policy and also our other policy with regard to school visitors and any other administrative guidelines that we have. The other option on this is that you would recognize a warrant that's not a judicial warrant. And so my recommendation for you guys is that you kind of track closely maybe with FERPA and that you adhere to the judicial warrant language in your policy.
And this is one of those that's not on this list yet today.
But we can go ahead. I mean,
Yeah, we can go ahead and add it now.
Talk through it, and then you
Yeah.
guys can have it as another copy in your second reading, since we kind of gone through this a little bit.
Yeah. And also, just so the board knows, in a situation like that, we have our SRO, Mr. Clemens, and our principal would get directly involved if that situation would come up. Those two would be the first point of contact. And our SRO is well versed in how to handle that situation.
I will tell you, I've already had a school district in here in Lake County where, you know, what actually happened with the student was already, there had already been an outside offense that happened, you know, a criminal thing that happened. And they stepped into the school and they gave us it really wasn't a judicial search warrant necessarily, and they wanted us to just give them information that we had in the file about the student, including the student's birth certificate, some other things, and they were working in conjunction with ICE, okay? And so I had you know, and it went with the school district straight to the SRO officer and you know, in central office, and they called me, and I'm like, well, this isn't really the kind of warrant that we can just immediately respond to because it's not a judicial order. you know, and of course it puts the detective a little bit in crosshairs with whoever's telling him to come get this stuff. And so I had a conversation then. What it led to then is the conversation with me and the attorney who's kind of behind the case with the federal court, you know, because there's some criminal stuff that was going on. And I just basically said, you know, if you can get me a grand jury subpoena or you can give me something else, and we can honor this, but, you know, we can't necessarily just honor it with what you've got, you know. So there's ways of working through it. It may not just be as expedient, but it's not like we're gonna get in the way of anything. We're just gonna make sure we have the proper request in front of us before we just get out student information. And honestly, I will tell you, just because, you know, and, you know, and I think Dave's more familiar with this than I am, but we do have certain pockets of the community that we don't know if they have, what their status is. We don't necessarily go asking for that. That's not something we collect necessarily in our student files. You know, I don't know, Dave probably has more history than I do, but I do know that we do have some pockets where, you know, we have had some places where we have kids and parents who won't even call the places and other social services because they don't know, you know, because they're afraid, they don't want to call something other, they don't know even about their neighbors and some other things. So this is kind of a little bit of a sensitive issue, I think, with a lot of our parents and families in schools who are trying to work with kids in Lake County. So, but that's really kind of your policy and what you guys want to do about that, so.
Let me, can you, one more time, the difference between a judicial order and a warrant? What's the difference?
So what happens is, under FERPA, when we get like an order from a court or a subpoena order, because there's like a live court action going on, and we get a subpoena for records, or sometimes we might even get a subpoena for the person, okay? And when we get it that comes in that way with the court behind it, then what FERPA requires us to do is to notify the parent that this has come in, because they have a right then to go and quash the subpoena if they think it's wrong. But there's a notice requirement that comes into effect before we can just simply hand it over, okay? Now, your question was about the difference between a subpoena order and a warrant. You know, and a warrant that's not a judicial order. ICE is not, there's not a court case pending. They have kind of basically an administrative function, and they have an ICE agent out there who can just issue a administrative order to go get documents or go look at people. But there's no court order behind it.
So that we don't really have to comply with,
Because
exactly you said?
that is what I'm
Okay.
saying, because under FERPA has references a judicial order, and there's not you know, this is sort of like, this would be like if Department of Education issued an order for record. Well, Department of Ed is not a court necessarily, it's just an administrative agency.
Okay,
Okay.
thank you.
Yeah, so it's just, I know it's really confusing, and I'm gonna tell you, it's so confusing that, you know, when this started coming up, we involved our immigration attorneys, who are far more familiar with what these things look like, and we've kind of put together, you know, with our school attorneys, with our immigration attorneys, we kind of put together kind of a, if you will, just a kit, you know, to kind of help, like, so that we know we're on call if these things kind of come up, and this is what a proper order looks like, and here's what a proper order doesn't look like, because it is very, very confusing. So
Okay.
your question is a very good question.
Thank you.
I don't mean to make it confusing, but I'm just trying to answer the
I
question.
know, I understand now. Thank you.
Mhm.
Would you want to go with the second one?
That's.
Is it
Easier.
a
Okay,
gotcha. Okay.
Oh, sorry. Yeah, the second one, this one is, I don't like this, I don't like the way it was worded. But the other one is on personal background checks. And so it really is, the way that there are options here with regard that, like what they want to see is that you're doing criminal background checks for people who are vendors or people that you contract with, okay? Because if they might in any way come in contact with kids, and maybe, you know, it could be like Skillman is doing, you know, contracted work on a building, okay? And so you're gonna do those criminal background checks. And I'm recommending that the cost of those go back to the vendor, not for us, okay? Because we don't want, you know, that should be on them. But one of the options that are here, and the wording of it kind of gives you a little heartburn.
A little.
Because it says the school corporation may employ or contract an individual who's been convicted of any of the following offenses if a majority of the board approves the employment contract as a separate special agenda item. And those items could be operating a vehicle while intoxicated, battery, domestic battery, contributing to delinquency of a minor, offense concerning a weapon, and offense concerning controlled substances. And then there's another option where it says that you may hire or contract with those people, with people who have an ankle monitor, people who have agreed to settle an allegation of misconduct with regard to health, safety, or well-being of a student in a school corporation, or one who's engaged in any kind of conduct regarding repeated and continued contact with a child that is intended to prepare that student for sexual activity, sexual predator, okay?
So that you can see why Ms. Conrad to go over these, because.
And what I don't like about the way that, I mean, what I don't like about policies, quite frankly, is that, like, I understand why they put this in the legislature. It's sort of like, you might have somebody that you guys, I just kind of, I haven't seen this yet, I'm just kind of thinking about when might this apply. Let's say that you've got somebody that everybody knows in the community, and let's say that person, I'm going to use he because, you know, kind of just fits the scenario. Let's say he got in trouble for something, you know, and it was a DUI, and it's on his record, and it happened 15 years ago, but everybody knows him in town, and maybe he's been part of the church, and maybe people, you know, he's learned his way, blah, 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 and now all of a sudden we know that he's working on a project at school, and he's a vendor for us, you know, and the board might say, well, we know him, and we know, we don't have a problem with him specifically and with regard to his criminal background, okay? And so what the statute allows you to do is to hire that person for that contract, but you've got to do that as a separate agenda item on your board agenda to hire them, okay? What I don't care for in the policy is that the way it kind of really makes, it kind of really, like, it almost feels like it says that you can hire all of these folks that have all of these things that might pop up, and it's kind of listed out there, and it's like, well, you know, I don't know by policy that we want to necessarily green light all of these kind of offenses, but I do think that if there was something to come up that's a special circumstance that's very unique, but we know that the board would just be able to have that authority.
To go a little deeper here, so say we're looking at hiring a vendor to come in, and just because Josh's here, we're looking at technology, some type of networking for us here. How would we, so are we required now to get a background check on these vendors coming in then?
Mm-hmm.
So moving forward, all of these, so for instance, if we had to start this auditorium project over again in October, we would have to ask Skillman to make sure all of their people, as well as who they're contracting in, have background checks on file, and to bring to us if there's any alerts, or do we have to go through, like, how would that look? Is it just more or less if they have alerts?
well, the third-party banner, so I'm gonna go through
Yeah.
your policy here. The board requires each entity operating as a contractor or subcontractor to do an expanded criminal background check, which they don't tend to do, okay? And who's likely to have direct, ongoing contact with children in the scope of their employment before but not later than 30 days after the start of their employment. So direct, ongoing. Now, if they were doing a project for you where there's no direct,
Mhm.
ongoing contact with kids at all, then you don't necessarily have to do that.
Let's say they're painting hallways during the school day. for-
That would be
for
direct,
30 That's
yeah.
direct.
Right,
That's-
but if they're coming in and they're doing networking, cabling,
Yeah, after school,
after school,
yeah,
and they're not,
that's not-
and nobody's around, then
That's not
you
covered.
wouldn't necessarily have to do that. So, you know, so that's where, you know, it really kind of comes down to that piece, is having that, you know, direct, the key is that direct, ongoing contact with kids within their employment. Now, I don't know, I think sometimes Stillman also does things to kind of, you know, wall things off.
Yeah, they do.
Yeah,
Yeah.
so, that, you know, there may or may not be any kind of direct ongoing contact. So that's, so my recommendation on that is probably just to not check either of those two boxes.
Okay.
And then what, and I'll get leave you specific.
Yeah, okay.
And then, but you guys will always know that if for some reason that there is a really, really, really unique situation where somebody who, you know, maybe they have a controlled substance, you know, issue with involving marijuana, and it's way back in their history.
Yeah.
You know, they never went and had their record, you know, had it removed from the record or whatever. I mean, you know, it's just, you know, but if it is on the record, then you have to make that a separate line item, and it has to be a board approval for their employment as such. Yeah, kind of interesting in how it's been kind of put together. And I also, Dave, on your options is tomorrow, if we do want to know reports for arrest and criminal charges, not just convictions. You guys want to, you do want to kind of control that.
Yeah. Thank you. Any questions regarding this?
Any discussion or comment? Haven't said that in a while.
Yeah.
Anything else? All right, can we get a motion to adjourn the meeting?
Motion.
Second.
Motion by Tom, second by Patty.